Okay, good morning. My name is Ronaldo Hilton, the chairperson designee of the New York City Loft Board. Welcome to our June 7th, 2018 public meeting. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the timely conversion of inter-multi-dwelling buildings from commercial and manufacturing spaces to safe, rent-stabilized residences that comply with the minimum standards of safety and fire protection as stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the loft law and the loft board rules. This morning I would like to take the pleasure of introducing our newest board member. This is Julie Torres Moskowitz to my left. I would like to take this opportunity to welcome Ms. Moskowitz to the board. Julie is a loft tenant and registered architect in both New York and New Jersey. She is the founding principal of Fed Nature Architecture, PLLC, and received her master's in architecture from the University of Pennsylvania in 2000 and a BA from the University of Michigan in 1993, where she studied African Studies and French. Julie is NCARB certified and a LEED accredited professional, and a certified passive house consultant and certified passive house tradesman, building envelope. She received her certification as a passive house tradesman specializing in building envelope after training in Dublin, Ireland. Since 2006, her practices has focused on a multitude of projects, including new construction, residential retrofits, commercial spaces, office building retrofits, park designs, passive house, FEMA flood resiliency, and nonprofit projects. Welcome, Julie.
Thank you.
And
I don't know. Push the red button.
just push the red.
Here, it's a city plan.
Hi, thank you everyone. I'm really honored to join the board, and it's nice to meet all of you. I met the staff last week, and thank you for the introduction. So I do have the architect point of view and life safety, and I'm excited to do public service and join everyone on the board. So thank you.
It's a lot of work here, Julie. Thank you. Okay, this meeting is primarily regarding, solely about rule revision. So this is an extra session held to discuss rulemaking. Ms. Awesome is going to lead that discussion where we left off in May with a proposal for 29 RCNY 208Q on page 29 of this document. Before that, I think she has some announcements today.
So, is this working? Yeah. Okay, so I just wanted to let everybody know that the Assembly actually passed the bill yesterday, I think local. So it is essentially the same bill that was passed last year, but the bill takes effect immediately. Of course, the Senate has to enact it, and the governor would have to sign it, but it takes effect immediately, and it also has a clause that allows people who were denied coverage based on the 2010 eligibility requirements to reapply, and it applies to cases that are pending before the board or on appeal. So I have the text. The number is 8409. B as in boy. If anybody's interested, I can certainly send copies around to the board members if they want to see it.
So after the meeting, you'll just circulate the text.
Yeah. I just downloaded it this morning.
This bill extend the deadline of when to apply for coverage?
Yes. It will eliminate the statute of limitations altogether.
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 So it's in perpetuity, is that what it
Yes.
is? Well, that's good.
Whether or not, I don't know what's going to happen in the Senate, if anything, but I thought it was important to report that this happened.
Did anyone read the Crane's article earlier this week?
Yes.
You did, right? It was a reading article about the other, about the article that talks about the two competing legislations. So,
Yeah, there is another bill that Homer subject.
yeah, which hasn't been yet had a sponsor yet in the Senate. So whether or not that happens,
No, where was that article?
I'll forward it to you. Crane's your business.
So as far as we know, the mayor has gotten behind this, the legislation in the Senate or not? The law,
I'm sorry.
has the mayor gotten behind?
Yes, the administration is supporting
Okay.
the GLIC bill, which is the one that was passed.
Anyway, okay.
Yeah.
What that is.
That's the article.
Oh, the article?
That's the article that Julie is passing. I think that's you.
The mayor has endorsed the bill that was passed. I don't believe the mayor is in favor of
Okay.
the owner's proposals, although
But it
probably
hasn't
not
yet-
again.
it
Yeah,
hasn't
I
yet
don't know.
been
Yeah,
introduced.
right,
Okay.
okay. Yeah.
Go ahead, no, sorry.
Did you have a question about the bill?
No.
Because I was going to go to the rules. Okay.
Oh, no, if you're going to go to the rules, I just, in addition to our new board member, I see some other faces in the room I've never seen before. Maybe introductions are in order?
So these are our summer legal interns, Ben Winters, who goes to Cardozo, and Trishawn Raffington, who goes to Custer.
Good.
You're with us for the summer for 6 weeks.
Good.
I should say welcome.
Okay, so in terms of the rules, so we were on section 7, which is on page 29 of the document, the revised document that I sent around. And thank you again, Mr. McLean, for suggesting that I add dates. It is much easier. It makes a lot of sense. So, Mr. Carver, you had talked about your concern that if the owner doesn't appear, what's the statutory burden on the tenant?
Right.
So I did actually reach out to the law department and had a little discussion about that. And the opinion was that there should be some sort of a showing, but they're not sure. They agreed that it shouldn't be that the tenant should have to subpoena everybody to find out what's in the building. So the proposal that was made, and we would have to flush it out, obviously, was that staff would develop some sort of questionnaire for the tenants to complete, which would be part of a coverage application that says, is there this in the building? Is there this, sort of like a yes-no checklist with a lot of the uses that would be covered, assuming that the legislation that was just amended doesn't pass, otherwise it would be much easier. So that's sort of where we're at. So I wanted to throw that idea out. So the rule itself could just say that the tenant would have to certify that to the best of their knowledge there are no uses no uses in the residential units that are inherently incompatible. And then as part of the application process for a coverage application, we would insert some sort of questionnaire.
So you're saying that we should have a lower standard of proof for tenants in this instance?
Yes.
Okay. Why?
Because, as I've stated over and over, it's very difficult for tenants to find out exactly what is in every unit in the building. They have no contractual relationship with the other tenants, unlike the landlord. So it's very difficult for them. They can't necessarily just knock on a door. Whereas a landlord, while it's true there may be no right for the landlord to have a right of entry in the lease that they have with these commercial tenants, but there actually may be. So clearly another tenant is not going to have that right.
It seems to me that the tenant who is living in the property has a better idea of what's going on there than an owner who's not living there. I mean, the tenant sees what's going on every day as they pass through the building. And the same records that are available to an owner through a FOIL of the fire department and the building department, and they do inspections based on the complaints of these very tenants who live in the building. there's the same pool of information available to both. I really don't understand why a tenant is held to a lesser standard than an owner. And what I'm saying isn't crazy. It's the basic American legal, it's a basic proposition of law. You know, that the party seeking relief from a tribunal has the burden of proof. I really don't think we should be tinkering with that. And I'm not sure how you legally can tinker with that. It's a basic proposition.
I gave some thought since our last meeting to your statement that the landlord may have no more knowledge of what's going on in the building than the tenant does. That and as you just said, the tenant lives in the building. To my knowledge, there's not a loft building in the city of New York that's worth less than $1 million, and many of them are worth many millions of dollars. So it seems to me, number one, that if whether the owner lives in the building or lives in Palm Beach, there's a certain obligation to know what's going on with a very valuable asset. There would also strike me to be liability questions where the owner needs to do due diligence before renting to other uses based on the existing uses. The other thing that strikes me about this particular argument is that, yes, to ask the tenant to say, you need to prove who you are, you need to prove you live here, you need to prove there was residency during the window period, those are all things the tenant can pretty much do. But if there's a big crack in the building, the tenant doesn't need to call an engineer, they call the relevant city authorities. At some point you're dealing with a physical structure where there's a responsibility for everybody to get to the bottom of what's actually going on. And the notion that the landlord doesn't know and can't find out, I find that hard to accept.
Well, of course, this is the tenant's claim. I mean, if I were in a lawsuit and I told my opponent that they had to prove my case, you know, they would say that I was crazy.
So, Mr. Carver, the tenant is just making a claim that there's no inherently incompatible use, right? Because obviously, from what they see and their own knowledge, right, there is none. And as Helene suggests, we will be able to have them complete some sort of a survey along that kind of supports their claim. The building code is in New York, for which all owners have to abide by, puts the owner squarely on the hook for maintaining his property in a code compliant manner. Correct? That includes the proper use of the building and so on. And so there's no way for an owner not to be able to do that without, you know, whether he absolved that responsibility or not, but he has to know what's going on in his building. He's leasing the building, obviously, to other tenants or himself, and having some sort of business there that he cannot legally lease out a building without, you know, for use which is not authorized. I want to dispel a little bit of notion here that you mentioned about tenants having knowledge of complaints that are, or just as much knowledge as the owners would, simply because there's a lot of stuff that happens without anyone's knowledge, and the public, the stuff that the city agencies respond to by virtue of complaints, are just what's visible, right? And if there's no complaint on the building, then no one will ever know what's happening behind a closed door. So who knows what's going on behind a closed door? Behind closed doors is more likely that of the owner, right, and the tenants. And so if the tenants don't see something happening, there's no complaint, and so there's going to be no knowledge of what's happening.
I don't agree with that proposition at all, and I think the buildings department...
Which part of it don't you agree with? The first piece or the second piece? Because it's the first piece I'm talking about, the owner's responsibility under the code to know what's happening in their building and the use, the code compliant manner piece, the maintenance of their building in a code compliant manner.
I think you really disputed that in fact,
You know, the owner, you're saying the owner has an obligation of knowledge?
Under the code, no. I said owner has an obligation under the code to maintain his property in a code compliant manner.
Oh, that's a true statement. But so what?
So, in order to, what I'm saying is that the code holds the owner already responsible for maintaining that property in a code compliant manner.
Yeah, so the standard lease between the landlord and the tenant puts an obligation on the tenant to operate the property in a...
It does not, at least does not absolve the owner.
Right, that's what I'm saying. That's how an owner does that. When an owner, in the first instance, maintains the property in a code compliant manner by issuing a tenant a lease that requires the tenant to do so. Because remember, the owner is not occupying the space.
Right.
Yeah. And yes, the local law would impose a fine on the owner if the tenant should violate the building code. But so what? I mean, why does it have to do this?
So who knows what's in the lease that the owner just signed with the tenant? The tenant and the landlord, correct?
It's a piece of paper that can be subpoenaed.
So you want to put a burden? So
The burden is, remember, it's the...
how many tenants will there be in a building?
This is the claimant, this is the claim of the claimant, this is their case. And I'm told many of them have, in fact, made complaints to the authorities for the very uses that you're claiming that it would be impossible for them to prove.
Can I?
Go ahead.
Can you explain in legally what preponderance of evidence means? That's in section Q.
A little more than half. So it's got to be more than 50%.
Well, the burden of proof is on the tenant, but what is the preponderance of evidence that they have to show?
They would have to, the person, the decision maker, okay, and it could be, I mean, at the basic level, it's going to be an oath ALJ, and then it'll come to the board. Has to find that this is so hard to explain, that it's 50%, more than 50% likely that there is no inherently incompatible use in the building, based on the record.
But that's being stricken. That's right. That's being stricken. That's in bracketed language.
Well, but that's what she asked. That was the question that she asked.
But I want to make clear that she understands the context of her question. So they're striking that standard and making it lower. That's the...
And they're replacing it with a questionnaire survey?
Well, that's the current, my current suggestion is to replace it with a survey.
In my layman's definition of not being an attorney myself, what I see is that this rule, if we modify it, in essence, we are saying that the law doesn't actually mean anything because we've just superseded the law, making the law somewhat null and void, that the 50% that she just explained is you don't have to show that. So now you can go make an allegation and not have to uphold the law. I think that's a problem. I think this actually puts the Loft board in a position where we're saying Well, okay, that's what the law says, but this is what we're going to say. That's what concerns me. I'm more open to this idea since Elaine has informed us that the law department somewhat agrees with us and is looking at other mechanisms as opposed to a complete strickening of this. But I'm still concerned that we can't just start coming in here and altering the rules and now making null and void what the actual law says.
Can I address that?
Can I ask a question to that point? And I guess my question is to you, Elaine. And let me step back a moment and make a larger comment, then I'll phrase my question. I was thinking about this week, and I think only Elliot, Mr. Schachter, and I were on the board when these rules, currently we're on the board when these rules were discussed and adopted in late 2010, early 2011. Mr. Roach may have been doing some assigned reading on behalf of the chief, who had a lot to say. But at some point, I think it would be helpful on this whole issue of incompatible use to kind of come to some kind of discussion and hopefully consensus on what it is we're trying to do here. And now my specific question to you with regard to Mr. Roach's comment is, what part of how to address the incompatible use question is in state law, and what part is in our existing rules that we're proposing to amend?
So the state law says that the building can't contain an inherently incompatible use, and the Loft board will pass rules that will define what that is. So I can give you the exact section, the exact item.
While she's looking that up, Chuck, what you indicated that you've been down this road before with the last, I guess, set of rules, and this obviously was put in there.
The current rules, yeah.
Right, the current
yeah,
rules. So I'm curious as to why now we find a reason to strike that when back then it was determined to be accepted.
It was certainly a unanimous decision, I can tell you that.
Okay.
In addition, let me speak bluntly. Somehow none of these cases have come out of oath, so there's a big hairball somewhere.
They're still at oath.
Yeah.
I don't have any that have been returned.
Right, and we've got people who are, you know, I've heard without them telling me the specifics of the case, but people saying, we're paying tons of money trying to prove this stuff. We've got to hire architects and engineers. It's a huge issue. And I would assert that this language that's in the Loft law was really a provision that was put in a chapter amendment in the second part of the legislation in the summer of 2010 as a method of limiting the number of IMD residents in certain buildings. I would point out that none of this applies to the 900 buildings that registered under 1982. Absolutely none of it. I could have a dry cleaner on the ground floor in my building. There was no mention of incompatible use. In my opinion, this was a monkey wrench. And when we first had the debates here, we had all kinds of wild ideas proposed and discussions of, well, what if there's an incompatible use on the ground floor in a 60-foot wide building on the left-hand corner, and the tenants live 15 stories above on the right-hand side of the building? Are we protecting them? And there was a lot of discussion and confusion. The other thing that I found odd is that after this very complicated set of amendments passed, the first thing that we dealt with in excruciating depth was this incompatible use. And at that time, I was of the position that it's going to take a lot of homework to do this, and we should also get some of the other parts of what was included in the 2010 amendments advanced first. But no, the board, for some reason, very clearly stayed with this. And tenants raised an issue that said, well, I make furniture in my loft. I use stuff to finish my chairs that's inherently incompatible. So our rule says that's okay, right? Commercial chair store, grounds for eviction, no, not grounds for eviction, grounds for the prevention of coverage. Use in the tenant's unit, okay. The law was then also amended to give us broader latitude in interpreting that, which we haven't really done as yet. So that I think if we parse out the difference between what's in state law versus what our rules were that we made at the time, that I don't think we're going against the law. I think we'd be revising our own rules.
In fairness, the difference in tenant usage versus commercial usage has to do, as fire department would tell you, with the amount of storage, these chemicals and quantity, I'm sorry, that would probably not make it unlawful in tenants.
Well,
right. There's a permittable amount of just about anything, as the chairman says.
Just want to make it
right, but
may make it permittable to do some.
and part of, as I understand some of these buildings, the issue comes down to, well, is the if there is indeed an incompatible use in a commercial unit that was there at the time that falls under the relevant use groups, is that amount permittable, or is it being ginned up as a way to create a situation where eligibility for IMD coverage is lost? There are a lot of issues here.
Well, no, I appreciate the backstory, because obviously that's valuable information, at least to this point.
Yeah, so this is from the MDL section 281.5. It's in the middle. The term interim multiple dwelling as used in this subdivision shall not include units in any building other than a building that was previously a multiple dwelling, that at the time this subdivision shall take effect and continuing at the time of the submission of an application for coverage by any party also contains a use actively and currently pursued, which use is set forth in use groups 15 through 18 as described in the zoning resolution of such municipality in effect on June 21st, 2010, and which the Loft Board has determined in rules and regulation is inherently incompatible with residential use in the same building, provided that the Loft Board may by rule exempt categories of units or buildings from such use, incompatibility determinations, including but not limited to residentially occupied units or subcategories of such units, and provided further that if a building does not contain such active uses at the time this subdivision takes effect, no subsequent use by the owner of the building shall eliminate the protections of this section, blah, blah, blah. So it specifically has the use groups 15 through 18, as described in the zoning resolution, and then it talks about the Loft Board passing rules. And this was part of the rules that the Loft Board passed. So the law itself doesn't talk about the burden of proof. The rule does.
So the rule can change the burden of proof.
Well, I mean, a lot of times there are, there could be a rule, like a rebuttable presumption, that there's a rebuttable presumption that there's nothing there unless somebody comes and says that there's something there, but I don't think that we should go that far. But you could do that.
Well, we have an issue with not only a burden of proof, but standard. But also, Chuck, I want to take issue with at least one thing that you mentioned. Laws make life safer all the time, so the fact that the older buildings were not subject to a safety provision shouldn't stop the legislature from passing a law that would make life safer.
Well, and I would just say in response to that the rather inconsistent exclusions carved out in 2010 in what was added to 281.5 that applies to only that group of buildings I don't think it makes anybody safer. I think what it really does is create a second class of loft tenants and create an unequal protection situation.
No, but we have to, I mean, we have to live with the law that we have. No law is perfect, and rulemaking can't go beyond the law. This is the realm that we're living in, even if there are safety inconsistencies in the legislation.
Well, I have a London proletariat point of view about this. I mean, it is, you know, my bottom line of all of this. And we know from a lot of statistics that a lot of creative people are moving out of New York City, basically because they find it difficult to afford the rent. So that's number one. And we also know that it's very important to keep the creative people in New York City, and in fact, it is a major way that the city is able to thrive. All right, so that's number one. Number two, I live in a condo where there are 6 unit owners. We've been in a dispute with this condo as to who has control over the building. The initial person that put the building together passed away, but his people claim that they have control over the building. There are things going on in that building that we don't even know about. And we have regular meetings. So I don't know how in the world, I mean, you look at that, forget that, Kent Avenue building with 60 some odd units in there. I mean, you think that the units all of them get together in an auditorium somewhere that doesn't exist in that building to try to talk about the incompatible uses or other problems that the building might have? I mean, that's just, I mean, it's, what it says, it's counter-indicative as far as I'm concerned, to sort of lay this burden on the tenant, and because the landlord lives in Massapequa or Boca Raton or whatever. I just, what?
You're not really proposing that you're taking any less responsibility off the owner. You're just stating that the responsibility needs to be equal.
Equal to finding information which is available to both.
I'm a little concerned that when you say, I mean, let's face it, human nature is we all want to kind of take the least path of resistance. If I'm a tenant and I can just allege something and say, well, there's no incompatible use here, have I done that just because I'm trying to take the path of least resistance when maybe there is incompatible use in the building and I'm just willing to turn a blind eye to it? I don't know. I think Chuck brought some backstory to this that I'm going to need some time to digest.
Yeah.
But
Well, you know, and one of the things I've said occasionally is that while my designated position here is to represent tenant interest, I feel the larger responsibility to the public. And if the concern of the legislature in its infinite wisdom was to prevent residential use in high hazardous buildings with high hazards, where the high hazard might increase the risk of either health issues or fire, then I have signed an oath back in the mid-'80s when all of a sudden the Loft Board got concerned. I don't know if they make people sign oaths anymore, but to uphold the law. Obviously, if your uniformed service has to put somebody on the roof of a building, that's a very serious thing. And if there are incompatible uses in there, there's a fire and it's 5 minutes away from hitting some really incendiary stuff, that's bad for your guys and women. It's bad for the people the businesses in the building, any residential units in the building. It could be bad for the building next door. It could be bad for the whole block. But what we're tripping over here is no, you're covered, no, you're not covered, you can't be covered because we got this. If there's a use there that's so incompatible that I can't live in the building, then maybe there's a bigger safety issue here than residential use.
On the other hand, I don't think we've confronted this with any building. I mean, I know that in the Gowanus Canal, they said that that's too dangerous to live in, but we haven't had any Kiwanis Canal lofts coming before us. So I think that one.
Surprise.
Well,
But that's a registered building.
another issue that we discussed in the backstory to this was, okay, the incompatible use is some kind of spray shop booth on the ground floor of the second floor. It's very well vented. Robert Lamondre treated us to a considerable discussion of negative pressure versus positive pressure. And the upshot is, yeah, here you've got a use, it's completely contained. None of the fumes go into the building. They all blow out on the street. So the people are going to be impacted by them, or the families are taking their kids to school, but we can't legalize your unit. So there's a whole, as I said, I think the legislature, whether it was intentional or not, this is not a provision like speed cameras in front of schools where you can say, okay, this makes sense. This is a monkey wrench, and the lack of specificity really is going to involve protracted proceedings at oath without real, so far none of these cases have made it to us, so I assume that they're grinding along, running up lots of legal fees with, we say this, they say that. So if we're talking about, you know, when we looked at hazardous uses, one of the ones that came up was crematoria, right? And I would agree that I don't think people should live in a building where there's a human or animal crematorium. But, you know, when you get down to what about the spray booth that's venting onto the street and isn't leaking into the building and people live on the other side, I don't know what we're trying to do here. I don't know what the legislature is trying to do.
Yeah, it's a tough issue. I mean,
But before you do, because I know you're going to wrap this up, but I mean, the claim of non-inherent incompatible use is just a claim. We're just trying to flesh out you know, how the claim can be made. I mean, the landlord obviously has a duty, I would think, you know, at least a right to come back and counter and say, hey, listen, no, there is a permit. Crematory.
One is on
On the first floor. So it can't, you know, it can't be.
Ronaldo, the reason the problem is arising is that the landlord need not be in the proceeding.
Need not what?
Be in the proceeding. So you're going to be left with this piece of paper with check marks by the tenant,
Why would they not be in the proceeding?
because this very board, I think last month, ruled that based on a default, an owner could not appear. I mean, an owner is not required to answer, and in that case, the tenant is put to his burden of proof. Am I correct?
So
That's the way it works now.
Yeah.
not being required, but I mean, would the owner have an interest? I mean, that's a no-brainer. But I mean, yes. I mean,
Look,
the owner-
anyone in any lawsuit, a defendant need not appear, but that doesn't mean that the plaintiff wins. So the plaintiff goes to court and has to prove his case to a judge without opposition. There's still a burden of proof on the plaintiff to prove its claim, even if the other side doesn't appear. And it so happens that it's not the case that in every coverage case an owner appears, and it's not the case that an owner is even required to appear in a coverage case.
Can I interrupt you?
Okay, so there were like so many things said that I want to comment on. In terms of, you know, why this was passed this way at the time, I think the motivation of the legislature is irrelevant. The fact is, this is what the law is. We can't do anything that's outside of the law, and I don't believe that staff is proposing anything that's outside of the law. So let's start with that. And if we are, certainly the law department will rein us back in. But I think, you know, hindsight is always 20/20, and at the time that these rules were enacted, which was shortly after the eligibility requirements came in, I don't know that anybody really contemplated how difficult it would be for a tenant, arguably with more limited resources than an owner and in an inferior position in terms of knowledge of what's in the building, to actually have to prove what's in every single unit of the building. And I think that that is how it's playing out at Oath, or at least that's the feedback that I've been hearing. And that is, in my opinion, an unfair burden on the tenants. So I think something has to be done. Could the board agree that if the owner is there, then it is the burden on the owner to assert, if the owner appears, that it is the burden on the owner to assert as an affirmative defense that coverage should not be given because there is an inherently incompatible use, and it's up to the owner to prove that. I think that's, you know, so we could separate the two issues, where the owner's there, where the owner's not. So I think that's one issue. And the feedback, we did reach out to the owners, owners and owner attorneys, and the feedback from that was, yeah, that makes sense. From the owners and the owners, well, from the attorneys. I don't know that the owners actually said that. And then in the situation, in the situation where the owner is not present and the owner hasn't answered, I don't know that it's fair to have the tenant prove every single use in that building. I don't, you know, and again, I'm thinking of very large buildings, and we have in Brooklyn very large buildings. So that's really the issue as I see it.
We've had a long history here of owners doing nothing. They're just ignoring everything. I mean, this is before the 2010, you know, the maximum fine that was $50.
Well, in fairness to owners though, Elliot, we've also had plenty of times where we've seen owners try to bring things to attention of the Loft board that they don't believe is safe. So I don't think we should
you're
start.
right. I'm not trying to demean all the owners in the loft buildings, but the whole tradition of it when this first got started was that the owners really just didn't want to have this thing happen, and they turned their backs on it for years and years and years. And then finally, when this new resolution came through in 2010, there was a little more, you know, now you have to do it. And we still have, how many of those 914 buildings that are not out of law? We still have.
I think probably a little under 200, although that's a
Yeah,
statistic that we don't.
And that's from 1981.
Could we agree to allow the staff to come back with a proposal that's somewhere between what Mr. Carter is feeling and what the high end and the low end of this? Because it sounds like even the city, it sounds to me like even the city law department said, yeah, you know what, there's some validity in Mr. Carter's argument. We need to take a look at this. So can we, you know, is that something we can do? Can the staff create something and bring it back to the next meeting for review? Or?
So you would be redrafting section 7 to say what? I mean, you know,
Well,
I can redraft it to say if the owner appears, here's what should happen, and if the owner doesn't appear, that's where we get stuck.
Why don't we see where the board supports the current proposed language first, and see if we can move on from that. I guess we'd have to move to vote.
Well, if we're voting on it, we should at least talk about the actual words.
Well, wait.
No, I'm not inclined to redraft this. Let's see where the guys support.
I'm not talking about
Let's talk about.
I'm not talking about a redraft. I'm talking about the language on it.
Absolutely, it's perfected. Then see where we have.
But I'm sorry, Richard. I didn't mean to.
No, that's okay. I might have even been hearing something.
Yeah.
All right. So the word allege is in there.
Yeah, so I would propose to change that to certify. And if it would make you feel better, it could be a support statement. problem with that is, well, they could certify, you could certify electronically. You have a sworn statement with an e-signature.
Well, it has to be truthful. I mean, the word truthful
Yeah.
wasn't in there.
Okay.
But I mean, I don't support this version whatsoever. But I'm just pointing out flaws in it as drafted.
Mr. Chairman, I just want to quick. You wanted us to take a vote on the existing,
Yeah.
as it stands right this instant,
Well,
not
I think-
before they go back.
That's right. I want to see if
Because I wasn't 100%.
if there's anything in the board that actually can pass the way it is right now. I'm not saying that the other way. I think the other way is complicating things too much.
The only thing is the manufacturing rep isn't here, and I think of all people on the board, he has the biggest interest. Or, not the biggest, but he certainly has a viewpoint that should be heard on.
I agree. There are two absentee members here, and I think we should hold this over. I agree with you. We should have a full board here, make this determination.
He, according to the rules, he's allowed to have someone sit in his place, right?
You know, an excellent question. You read the rules. Let me give you a 2-minute backstory on why we had that provision. At the time the Loft Law was originally constituted, the first landlord representative, who was an IMD building owner by the name of Thomas Berger, had a close family member, I believe it was a sister, who was seriously ill in Australia. And he had to, and this week, I mean, you think what we're doing now is crucial. This is in the first months of the law board when we were trying to write the initial entire framework of rules. So it was at his request that the board have a provision that if one of the special interest members is absent, if the other board members accept, they can allow a designee to speak on behalf of that representative, but not have a vote. That's the gist of it. And it's never been invoked.
Look,
How is that going to help?
Irregardless, he's not here to say that somebody else can speak for him. He said,
we know who he is. We'll just wait for him.
a good point, though. Actually, I mean,
Yeah, if we're trying to get things done.
It's educational to bring that up and discuss it. And it's just in this particular instance, at this particular moment, I don't know if that access.
All right, but if you're asking if anyone is interested in it as written, I vote no.
Let's talk about the language changes first.
All right, so from the word alleged, we can change that to certify under the penalty of perjury. That, to the best of their knowledge, there are no uses in the residential units that are inherently incompatible with residential use, blah, blah, blah. So certify under the penalty of perjury, that, to the best of their knowledge.
I thought you said there was going to be some sort of a form.
Yeah.
Well, yeah, but you want the form in the rule? I mean, that,
I would think you would want to say on a form prescribed by the law.
okay, certify on a form prescribed by the law.
But again, I think this is a terrible idea, just to be clear.
You're helping us with a terrible idea.
Wait,
That's just who he is.
is that about? So
Yeah.
the form would say, we would say certified on a form approved by the law board under the penalty of perjury.
Prescribed by the law board. Certify under the penalty of perjury on a form prescribed by the law board that, to the best of their knowledge, there are no uses in the non-residential units that are inherently incompatible with residential use, blah, blah, blah.
So that form just simply doesn't be notarized.
Well, I think it could be e-filed, but there'll be a certification that says I certify under the penalties of perjury that, to the best of my knowledge, there is not. I'm answering this truthfully, and I envision, yes, the check-off boxes, but it doesn't necessarily have to be. We have to figure that out. I mean, it's at this point, it's all moot anyway, because we can't take coverage applications, but hopefully that will change.
if can we also put something in there, if the loft board staff deems desirable, or if the loft board deems desirable, that inspectors can be sent to the property to inspect?
Well, we already have rules that say that, but we could put that specifically here.
Because, you know, here again, I mean, we have access to sworn inspectors, from all the different organizations. One of them is actually employed by the loft board, and you have the fire department representative. And one of the things that's always concerning is that I don't think we actually get into enough of these buildings. This would actually possibly open a door, and I'm not saying it would have to be in every case, but if the staff were deemed appropriate, an inspector could be sent in the direction of the chair or what have you.
So a matter of correction.
I was just wondering if the manufacturing incompatible use group 15 through 18, if they have to be in continuous operation, or if it was just from 2010 until the time of the filing.
I think you're asking, I think the window.
I'm just wondering if an inspector there might not be a business there anymore. Is it based on a past?
Well, it has to be, go ahead.
Well, the applicable period in terms of how it would play out in real life is it would be during the window period and then at the time of the trial, because the record would close, and that's what the board would be considering in terms of a coverage application, right? So let's say that there was a crematorium, right, that was there during the window. How do you use that?
There's another one, a freak show. I thought that was funny. So, use group 15 is a freak show.
That's amusement, right? It's amusement, right? It's amusement stuff. Yeah.
Right.
So
Coney Island, I can't remember.
Right.
you can't live under the same roof unless you're Woody Allen. So anyway, let's say that there was a crematorium that was there, it was operating during the window period, and it was operating during the trial. When the board gets that record, and that record is in front of them, what the board will know is that there's a crematorium. Now, if the crematorium has ceased use, someone would have to inform us of that. I assume that the tenants would try and do that by filing some sort of motion to reopen the case. Or maybe the board would rule, deny coverage, and the tenant would file a request for reconsideration saying, here's new evidence that wasn't available at the time of the trial. So it could play out one of those two ways. But either way, that information would have to get to the board. Does that make sense? Did I answer your question?
Okay.
So why is the certification not coming from an architect or an engineer? I mean, ordinarily, it's a technical issue that would ordinarily come from a professional when the owner was doing the registration of the building. Why shouldn't your certification come from the architect and not the tenant? At least you have something more than the self-interested tenant in the outcome. I mean, I think the building department should be interested in full proof, full F-U-L-L proof of whether or not you have this hazard. But at the very least, I think you would want it to come from an architect or an engineer, and not the person who will benefit from a conclusion that there is no incompatible use.
So are you laying the burden of proof on the tenant or the owner or both in terms of finding an architect?
This is always the tenant's claim.
So then it's the responsibility of the tenant to hire an architect where the owner doesn't necessarily have to do that? Is that what you're saying?
No, the owner would have to do that when he's finally ordered to actually register the building.
So And that form that's, that we talked about, the form is approved by the Loft board, or?
Yeah, that should be signed
How
by
do
the,
you sign that?
it should be also signed by the architect.
Well, can I just say that that goes back to the idea of, well, who lives in the building and is there every day? So are you going to have somebody who's not there, who's hired to come in and take a look, who can't get into all of the spaces, put their license on online?
Well, you're asking the same thing of the owner after the owner is not appearing, and then you order him to actually register the building.
Well, the owner chooses not to appear. Assuming that there are no service issues, the owner is choosing not to appear. So, I have no pity for that.
No, just out of curiosity, I don't know that your idea is bad, but since we have one now as part of our board, I'm a little curious, how would an architect approach such a request? Because you don't have, you can't force yourself into these spaces either.
Right. I was thinking of what we have to do for energy code, where we say to the best of our knowledge, when we stamp, sign. So it's a little bit of, it's not, maybe that has to do with burden of proof. It's not 100%, but it's...
You have to at least try it now, basically.
Right.
I mean, that's certainly better than...
Yeah, I mean, if you think
that,
again, I just look at it like, even city agencies have a hard time determining what's going on behind closed doors. So I was just curious what approach an architect, may take in that instance. If I'm a loft tenant and I called you up and said, Ms. Moskowitz, I'd like to employ your agency to come in here and determine that there is no incompatible usage going on in my building, if you all have some sort of a, probably not a cookie cutter approach, right? It would probably depend on the circumstance.
But if you're dealing with, as a hypothetical, a building with 8 residential units and 16 commercial or manufacturing units, then the architect would have to attempt to gain access to all those units.
Well, I'm not, that's why I was kind of asking the question, because I'm not thinking it would be easy.
Well,
Well,
again,
how does the owner do it when he has to certify the building? You're asking the same thing of the owner. Why can't you ask the same thing of the
Because it's the owner's building, and the owner is supposed to know what's going on in its building. I mean,
Well,
the owner is the keeper of the records. The owner has the leases. The owner knows, theoretically, although we've had owners that don't necessarily know how many units there are in the building, but the owner theoretically knows what units even exist in the building.
The owner could actually make a statement that, to the best of his knowledge, because he knows, what he has on the lease more clearly than tenants, right? Because to the best of my knowledge,
It's not right. No.
It's not. No.
The same information is available to both sides.
Well, that's not true. The owner has the lease. The owner has leases theoretically in their office. The tenant does not have those leases.
If everyone does their jobs, if the professionals subpoena the records, the same records, the records of buildings, of the fire department, the leases, that's all available to everybody. This is like any other civil litigation when records are in the hands of someone else.
This isn't civil litigation. This is administrative law.
It's the same principle.
I'm not against the architect idea, by the way. I was just kind of curious how it would play out.
I'm kind of against it.
Would be beneficial. If you think it's beneficial, I guess if you don't think it would be.
Can we see if we can?
I just want to point out that the oath judge can get, through an order, can get access for the tenant's architect. So access is not an issue.
Let's revisit Mr. Roche's idea about the Loft board's inspection. Even though I just want to correct the record, the inspection that we have in the Loft board does not work for the Loft board.
Oh, I'm sorry.
Yeah,
I guess he's assigned to it. Assigned to it.
Right, but and I'm not sure how qualified that inspector would be anyway to make this kind of determination, because
I would say you need a D.
right, you need almost more of a fire or something. But I'm wondering if we could probably we could probably phrase it where the Loft board may used by the users. I don't know if I'm going to suggest something crazy.
Agency deemed appropriate?
As Loft Board deems appropriate, it may elicit the assistance of other city agencies to conduct an inspection, or to try to.
I mean, I think what we should say is that the Loft Board may request additional information or inspect as needed, if there's a reason to do so, or something along
And
those
how we
lines.
inspect,
We have a rule
and
that's
how
similar
we
to that.
inspect, it would be up to us, like whether or not we're doing the inspection ourselves, or we would be asking the fire department to do an inspection, or the building department to do an inspection, or HPD, or DEP. But we would probably request the services of another city agency to do that, if we
I would think
deem appropriate.
I mean, unless you, like I said, maybe the language, the agency which would be deemed most appropriate,
Or agencies.
or agencies which would be, I don't know that, you wouldn't want to probably put the burden where you would have to say. Because
No, say
theoretically,
may.
somebody can
That's
come
what I'm
by and say, well, HPD should go, DOB should go.
But that would be the Loft Board's decision.
But that would be the law board's decision.
Can I ask a question? Fire prevention. I would assume that when we're talking about hazardous stuff, there are a variety of different kinds of hazardous things.
You see the whole gamut.
Right, and-
We've had issues just like you described, where people were concerned that the fans are blowing
Yeah.
fumes and stuff out onto the sidewalk.
And would I be correct that you've got different people with different areas of expertise?
Oh, absolutely.
Yeah.
We have, yeah, as Ronaldo well knows, we have everything from a labs unit of people that specialize in laboratories to sprinkler standard specialists to
Right. So if there's an allegation of a certain kind of problem, you try to send out the right people.
absolutely.
Who,
Yeah,
who.
absolutely.
So to have Arthur Atlas, architect, who knows about legalizing units, go around trying to figure out what this is and how much of it, how much is there of it. I don't know if this is something that's really, to a certain level, if what we're really out to do, and again, there was tenants who expressed concern at the initial hearings back in late 2011, or 2010 or early 2011. You're asking us to prove a negative. I mean, theoretically, if the tenant has to prove, it almost requires them having a battery of experts on call to be able to say, oh, well, it's a dry cleaning establishment, I'm going to need this, or it's a medical supply, they might have radioactive stuff, I'm going to need that. So,
And I think, I can't speak necessarily for HPD, but I sort of think DOB kind of has the same expertise. Yeah, I mean, they have plumbing inspectors, electrical inspectors, structural.
The guy who does the roller coasters.
inspectors, so
Yeah.
I'm pretty sure they could attest to the fact that they would approach it the same way. So we do have our man of the hour here now, though. May want to weigh in on this.
Yeah. What were your point though?
Well, Elaine said earlier that the tenant has less resources and is in an inferior position to make these, to discover this. Mr. Carver feels strongly that the burden of proof should be on the applicant. But if you take a step back, what we're, I think, really trying to do here is guarantee the health and safety of the people in the building, whether they're living there, whether they own the building, whether they work there, or whether they walk by or live next door. So, insofar as the legislature in its wisdom charged us with all these different groups, then maybe this is a situation where the default has to be to a body of expertise, that it really would be unfair to ask either the owner or the tenants to assemble. I mean, if the issue is just preventing IMD determination, that's one thing. But if the real concern here is health and safety, which seems to me it ought to be.
Bottom line, I mean, there's other little ancillaries that are floating around that, but I think that's the bottom line, obviously, is the health and safety.
So how would that work, though? How would that work?
Well, we were just headed down the avenue of inspection.
Okay.
I don't want to put monkey wrench in that. There's a building in my neighborhood where someone moved in and there was a tremendous amount of noise of the heating and air conditioning. The owners of the building, or one of the owners, one of the tenants of the building, called the city and they went in to take a test of the sound. The unit happened to be off at the time, so there was no, they couldn't determine whether the decibel was that. The next thing the owner did is he put up a steel gate, and the city was not able to get into the courtyard to take a decibel. Now, all I'm saying is that it is extraordinarily difficult for either the city agencies that are overburdened. You know, if you're redoing a bathroom in your residence, you have to get somebody from the city to come in to check to make sure that it's done properly. Very often, the city can't even send an inspector there, in which case the plumber has the responsibility of sitting there and waiting for the inspector to come. If the inspector doesn't come, the plumber themselves can check it off and be all right. So this is a very clumsy situation, I think. And then to lay all of this burden on the tenants, I think is just, to me, it's kind of ridiculous. I don't know where we're going with this. And the other hand is that how many times has this come up?
Oh, well, the case is still at Oath, so it hasn't actually come to the board at all.
So I don't.
So in reality, what happens, right, is maybe you guys, staff, can help me out here. In reality, what happens? The tenant would say, what right now, currently? Nothing.
The tenant says in the application that there are no inherently incompatible uses, and then it would go to Oath, and at Oath, the tenant would have to say, here's what's in the building, and they are not inherently incompatible.
Right. And the tenant would also have to go back to the window period, correct?
Yes.
The tenant would have to go way back 10 years maybe, to the window period and say, 10 years to window period and say, yeah, and that existed during the window period, that didn't exist in the window period, right?
That these are the uses that were in the building during the window period and are there now, okay? And none of them are inherently incompatible. So yes, they would have to go back to the window period.
So who has the best record keeping ability here? The tenant, one tenant, two tenants, or whatever, or the owner that has had complete full record of what's going on in the building during that period? That's mine.
Who's to say it's the same owner? Anyway, it sounds like this kind of conclusion of whether there's an incompatibility has to come from an architect or already a PE. And there's no reason why.
Why? Why does that conclusion have to come from an architect?
Because I don't see how a layperson can apply the definitions in the zoning to conclude. I mean, I don't even know what I'm not clear what a use group is.
I brought them all.
Okay, but
So
you're telling me, I'm being told that tenants are confused at a narrative statement hearing when they look at a piece of paper, let alone they have to try to figure out if a particular use satisfies some technical definition in the zoning. So I think ultimately a certification by a tenant is not very meaningful.
But that same logic would say that the owner is not capable of saying what use group is in their building. And that's...
An owner is required, when they ultimately register the building, to have an architect make this certification. Why shouldn't the tenant also in this context? That's all I'm saying.
So again, it all comes down to the issue of being able to actually know what's in the building.
So are you saying, Mr. Carver, you would be open to maybe something in our rules that says the owner shall provide access, complete access for inspection by the tenants so that they can make that determination?
I believe an oath judge has that. Am I right that an oath judge has that power now? This is no different.
I think that's both procedural rules. I'd have to look it up, to be perfectly honest. If it was ECB, I can tell you, but trials and chicken.
So I'm not open to any change of the current rule. I'm obviously just seeking to make your changes better.
Okay. So let's just try to make these changes better than the rules.
Well, I very much like our item that we want to do about the inspectorial component being able to be utilized. Because I think, like Mr. Delaney said, the bottom line here, cut through all the ancillaries, is we're concerned about the health and welfare and safety of anyone living in the building, visiting the building, or otherwise. And that inclusion of that component in this area would put the board in a better position to be able to feel that we're making a safe, educated decision on behalf of the tenant, visitors, or anyone else.
So let's go back to that.
So we do have in Chapter 1 a proposed rule that's based on the current rule, which is 109, but the proposed rule is 1-24. It's on page 17 of today's document. And it says staff may investigate claims raised in applications or any other documents filed with the Loft Board. Staff may request the parties furnish additional evidence or memoranda relevant to the application, request appropriate ledger documents, other records relevant to the issue of dispute. So that's staff requesting additional information. We could cross-reference, although I hate cross-references, we could cross-reference back to this rule in 208Q.
That would remove the onus on the owner, right? No,
What do you mean the
We
onus on the
remove the
owner?
onus, aren't we arguing that the onus is on the owner to have to then validate and confirm the space itself?
But what the way that the rule currently works is that the onus is on the tenant to prove that there is no inherently incompatible use, so it's proving a negative. So if the owner is appearing and saying, hey, there's an inherently incompatible use, I don't think that that's really the problematic case. The more problematic case is the one Mr. Carver raised, which is, well, what happens when the owner isn't there? So we're trying to craft something that puts less of a burden on the tenant, because it's very difficult for tenants to prove this negative, but still would satisfy that there's enough proof for the board to act. So we want them to do something, but clearly what we've asked them to do in the current rule has turned out to be unbelievably burdensome, so burdensome that these cases are at oath for 10 years.
So can I suggest then, I'm not a lawyer myself here, that we can say something like, in cases where owner does not appear, staff may reference back to that section.
Yeah, pursuant to 1-24.
Yeah, staff may conduct its own investigation pursuant to 1-24 for rules in making, in making, clarifying or whatever the issue of inherent incompatibilities, something like that. Do you want to? I mean, you want us to break from this so that Elaine can, not now, but next month, come back with, or this month actually,
Yeah, next
come back, next meeting, come back with a language around that. It would be fine. fun here, so we don't spend the entire day here. I'm kind of open to that. Yeah.
So if I could just get a consensus from the board as to whether or not you think there should be a certification of an architect or engineer.
Yeah. I'm sorry, I'm not the only board.
Who would be hired, I guess, by the tenant to do that? Just so in drafting I can put that in or not.
So the question is, should the tenant be allowed to make the certification as an individual versus needing a professional?
Right. Yes,
Yeah.
I think it's a good idea.
Could it be an option? Because I think we're still sticking with, we're going to put something in there that says certified under the penalty of perjury. So if you put it the option, the tenant may say, you know what, I'm not going to sign this paper. I'm going to hire an architect.
Well, if I were the architect, I'd say, I'm not going to sign this paper.
I don't know their world as well.
That's what I'm afraid of, is that the tenant won't be able to find an architect, because then the architect would probably want to, and rightly so, see everything that's there so that they could honestly issue a certification that says, yeah, this is okay.
But we want that. If you're concerned with safety, don't you want that? I mean, I'm shocked that the building department is taking such a light hand on it.
We're also very concerned with fairness. So,
Fairness overrides safety?
no, we're not.
You need a
No.
balance.
Right, so, here, let's take a stab at any redraft of this. Somebody has something. No. Let's take a
I
stab.
think there's a concern about finding an architect. I was just going to ask if we get our architect's opinion. There are
Listen,
firms out there that would agree to do something if it had this state.
These uses are defined, am I not right?
Yeah.
We're not giving a lot of credit to people, just being able to sit and read and observe what they're seeing every day or not seeing every day. So let's leave it at that. Let's leave it at that. I don't, honestly, between you and me, I really don't grasp why anyone would want to expose themselves to some of these uses, deliberately expose themselves to some of these uses in the building and certify that I'm living next to something that could cause me to die in the next year or so. If people are, if that's a problem, if anyone sees that rampant
We got a bigger
thing,
problem.
we got a big problem. All right, so I think we need to let's move on from here. Helene, could you just try to
I
redraft?
will try it.
I don't think you need necessarily, you definitely don't need an architect engineer to do that. And certainly if the city was going to do inspections, a lot of these inspections are not going to be done by architects and engineers.
What I'm wondering why the inspectors, so I thought there was some conversation earlier about having inspectors validate or confirm.
That's invoking that.
I think,
yes.
yeah, well, I don't know that we necessarily want to go there, because I'm not sure that the city has the resources, and it would involve multiple agencies.
Great.
But it's definitely practice now. So if you go into a building and trying to determine what the use of that space is, you file a complaint with the Department of Buildings, the inspector is sent out, and that inspector then determines whether it violates code or not. That happens now already.
So that's, I think, complaint code number 45, and there's a couple of other complaint codes in there that allow you to be able to justify whether,
To determine what that use
So
is.
you're saying the law should file complaints?
I'm not sure who you can, but I think that's, but
If we're looking at validating and confirming, you can go ahead and you can make a request to.
Yeah, but that's what, is that the language we're going to try to put in, say the law board may invoke?
That we may investigate claims raised in the applications. That could involve inspections or other things.
That's already in there.
Well, that's in chapter 1, yeah.
Yeah, so all we're really doing is making reference to the fact that we can do this.
But
Yeah, we may, so.
I don't know that we want to put the burden on the city to do those inspections. That's,
Well, but speaking from the fire department's perspective, we want to get in these buildings and see what's going on. Please call us and ask us to go do the inspection for the record. I mean, I'm not going to speak for other agencies, but this gives us an opportunity to get into a building that otherwise we may not be permitted to go into unless somebody dials 911. And see with our own two eyes the safety
And vacate the entire building?
and welfare. Excuse me?
And vacate the entire building process?
No, I don't, I mean, here again, a lot of people, I know of zero record in the last 5 years, I'll say conservative, when the fire department has vacated a building because somebody has sent us there on a complaint. Building vacates done by the fire department are done because we are finding people stuffed in attics living and stuffed in basements living. The fire department vacate criteria is not, again, it hasn't happened. You wouldn't be able to show me one case, I don't think in the last 5 years, where the fire department vacated a building because there was some sort of issue with incompatible usage in the building. Now, if in the process of going into one of these buildings, we find out that the owner has sublet the basement into 12 SROs, but that's a safety hazard in itself. So certainly, here again, this goes back to what you said, Mr. Chairman. I mean, we got a bigger problem if we're running into this kind of thing.
What you're saying is that what you're suggesting is opening up that possibility. You know.
No, I'm suggesting
Does the
that if
FDNY
somebody-
have their own protocol? For example, in my building, we have sprinklers, and FDNY has always done normal visits to our building over the years.
Correct. Correct. But we don't have, we have the same issue getting into a private space. So your particular loft, okay, unless you invite us into that loft, we would have, ultimately, if you say, inspector, chief, whatever, you're not coming into my loft. For us to get into that loft, we would have to get a warrant, and here again, it's just not done.
Unless there's smoke coming out of it.
Well, that's not a warrant, that's, yeah, if there's an emergency, a 911 emergency, we're gonna, that's a different story. But once somebody dials 911 and says, I have an emergency at my building, state law is when that fire chief arrives, that building is now under the authority of that fire chief. And it doesn't matter if the owner's standing there saying you're not going in, or the tenant's standing there saying you're not going in. If there's smoke coming out of the building, and the call was originated as a 911 call, guess what? We're going into the building, and anybody that try to stop us is going to be removed by the NYPD.
Well, let's
So-
hope that doesn't happen.
Well, I mean, that's a fact. That's state law.
If someone walks by a building and see there's a fire, and the tenant doesn't call you, then you can go in there and break down the doors and get
Well,
into
no,
the
you're saying that we wouldn't, how would we know if somebody didn't call us?
No, but let's say a pedestrian called you. You would then go into the building. and
If we
break
got
down-
there and there was a fire,
And
absolutely.
you break down the doors and get into the building.
Well, to access, we're not gonna, I mean, if it's a large building, we're getting way off track here, but, I mean, if it's a massive building and the fire's way over here, we're not gonna be breaking down doors
No,
on this
of course
side of the
not.
building. But in a loft building like you would find within maybe a 5-block radius of here, yeah, absolutely, we're gonna do what we have to do to go in and mitigate the emergency. And the law allows us.
Yeah,
the-
my only point is that you have more responsibility to do this, the fire department, than city agencies.
Okay, but
Well, I'm just speaking.
Listen,
for you.
we're talking about non-fire emergencies here. So
Hopefully.
let's move on. But I appreciate the discussion. I think we're going to just take a pause. Helene will redraft something as we talked about, and let's continue for 2 weeks with the new language that will come up. And see.
I have
You have another suggestion?
a legal concern.
Okay.
Look, if you're not requiring proof of an element of a claim, through a rule, isn't that in essence nullifying the statute itself? And wouldn't the rule be ultra-virus?
So there's always a chance that a rule could be ultra-virus. I would argue that it's not that we're not requiring proof, it's that the type of proof that's acceptable. I don't want to use the word watering down.
Lowering the standard, that's it.
Yeah, that we're lowering the standard that of the types of proof that would be acceptable. Ultimately, could a court say that we were ultra vires for doing that? I guess they could, but again, I did talk to the law department about that, and I'm confident that if we do a little more than we had originally proposed, but still move away from the current rule, that we will be on solid legal ground.
Not that I'm interested in this result, but I think it would be worthwhile to get very specific with the law department and actually see what authority they're resting on to conclude that we can make the standard approved law.
So, Mr. Carter, the law department is going to review our rules anyway. They're going to shoot it down on the floor. Right. We're proposing the rule, and then it's going to be reviewed by the law department, and then there's all.
Just to go through the process for a second, we're still discussing our draft.
Yeah.
Correct.
Right. At some point, we will vote the entire set of proposed amendments for both Chapter 1 and Chapter 2 out in public comment.
Correct.
Law department looks at it before that.
Correct.
Law department looks at it in after.
Correct.
So they're going to have ample bites at the apple.
And the mayor's office of operations also works for
The plain language. Can you, if we're ready to move off of this topic, can we just kind of summarize what your homework assignment is?
So my homework assignment is to redraft
At home, please.
the rule in section 7. And I'm not sure whether or not I should put in architect and engineer or not. So, and I will redraft that language, and hopefully it will be language that the board can reach a consensus on. So clearly we're taking out allege, putting in certifying, we're adding the penalties of perjury, we're adding the form prescribed by the board. That's what I believe I'm supposed to do.
And the open question is whether the individual signing that needs to be a professional.
Well, I think that the tenant should have to sign all this.
It's the tenant's application.
Yeah, so I think that the tenant should have to sign whether or not there should be an additional signature. I would view the architect and engineer as an additional signature. Like if you want to analogize it to the registration, well, the owner is ultimately signing the registration and swearing to the truthfulness, swearing or affirming to the truthfulness of everything that's in the registration, including the certification by the architect.
All right, so in essence here, the architect would be relying on a actual record that's certified by the tenant.
I don't know. I mean, it could be that an architect, when asked to do this, or a professional engineer, when asked to do this, would say, well, I'm going to walk over to the building and take a look around and see what I see. Right? I mean, I think that would be prudent of the person. Their license, they have to worry about their license, and that's a big deal. But I don't know. I'm not one of them.
It's also about the past, so
Yeah, that's the tough part.
Google Archives or something of the building.
So let's take a draft of the architect engineer piece right now, and let's move on. Thank you. All right.
Okay, so I'd like to turn to the document that Mrs. Delaney submitted, since it's sort of on the same theme, which is a proposal to amend section 208K, use groups and uses and use groups inherently incompatible with residential use, pursuant to MDL 281.5, use that falls within use groups 15 to 18, as defined in zoning resolution, in legal operation on June 21st, 2010, and continuing at the time of submission of an application for coverage by any party that is also set forth in the appendix to these rules, and which poses an immediate hazard and threat to the health and safety of the residential occupants of the same building that cannot be reasonably resolved through legalization of the building, is inherently incompatible with residential use in the same building if, et cetera, et cetera. So the proposal is to change in effect to illegal operation, and then to add the language, and which poses an immediate hazard and threat to the health and safety of the residential occupants of the same building that cannot be reasonably resolved through legalization of the building. So this is the way it was your proposal, so I guess you should talk.
I think it's pretty clear on its face. One of the issues of concern is, and I guess this goes partly to your assertion that the landlord really doesn't know what's going on in the building. So if the...
I never said that, but go on.
Oh, maybe I misunderstood.
No, I said that the state of facts is equally available.
Oh, yes, I heard you say that, but I also heard you say many times that it's very difficult for the landlord to know what's going on in the building.
Maybe I didn't say the blanket proposal that you said.
Yeah, well, the point being, perhaps one concern is health and safety. Another concern might be, well, we don't want to have to force an incompatible use that existed prior to the passage of the law to leave the building. But that should really only apply to an incompatible use that's operating legally.
Yeah.
Well, what I see would happen, and again, I want to just defend the fire department here a little bit because the term vacate keeps coming up. If we ended up someplace and there was an incompatible use in operation, the worst case scenario that's going to happen is that the operation will be shut down until such time that it could be made legal, safe, and done without some sort of problem with the health and safety of the rest of the people in the building. We're not going to vacate somebody from a fourth floor loft because there's a manufacturing facility operating on the first floor that isn't operating safely and doesn't have all the permits and everything. We're going to shut that business down or that entity down until such time that they get everything safe and squared away. And by shutting it down, that eliminates the hazard to anybody else that may have to live or work in the building. But I think that sort of plays into what you're saying there.
Yeah, obviously, and if you find, I mean, let's take a kind of storied example of houses or apartment units that have been used as meth labs, right? Very toxic, very risky to everybody who might live in that unit in the future, people who live in adjacent units. The authorities are going to take the necessary steps. It has nothing to do with whether it was in legal operation, right?
Well, correct. I mean, case in point, we had a battalion chief killed in the Bronx within the last 3 years. Because there was just exactly what you said. There was a drug operation operating in this structure, and it was an explosive atmosphere. And unfortunately, the perfect storm occurred while the fire department was there, and the place blew up, and the chief was killed. But we're not going to walk away and let them continue to be operating there with ammonium nitrate and all these other fertilizers, in essence a bomb, and allow other people to be living there. We're going to mitigate the hazard, which would have been, in this case, in the ideal circumstances, hazmat team would have come and secured all the ammonium nitrate, anything to do with the drug operation that wasn't legal, in conjunction with the NYPD, and remove that from the structure, and all the rest of the people living in the structure would go on with life as normal, and that hazard would have been removed.
Right.
Since you used the term meth lab, we had, unfortunately, actually.
Yeah, no, I remember reading about that. So the concern here is that if the residential units cannot be covered under the law because there's an incompatible use, that incompatible use should be one that's legal under the zoning for that building. That's the proposal.
Yeah, I get you, but the second set of,
Right, and that goes to the issue that I discussed earlier with regard to, yes, there's an incompatible use here, but it's entirely sealed off from the building, so it's no danger to the residents. The real danger is to the people who are passing under the ventilation that blows the spray booth, pollutant out into the street. So that this is calling for a demonstration that the incompatible use actually poses a hazard to the health and safety of the residential occupants, or we could strike the word residential and just make it the occupants. It's the same concern.
Are we requesting some sort of test to confirm this, or because it just seems like an additional burden on the property owner?
Or the tenant.
Yeah.
You just want to say tenants instead of residential occupants?
it doesn't matter what you say here, but no, my concern is an inherently incompatible use is one that's already immediately hazardous, correct?
Yes.
Correct. It's already known to be of some sort.
Yeah, but then we went through a whole lesson, and I think I failed it, on high hazard, A level, B level. The chief had a ton of information he shared with us.
He's really sharp at that.
Yeah.
Yeah, there's all different levels of,
So
all different levels of hazard.
So the big issue is here, in my opinion, is Mr. Delaney, is that buildings could take for I wouldn't say forever, but it does take a while to go through the legalization process. And you're stating in this, in your draft here that as long as it can be handled in the legalization process, we should allow that use to coexist until and if it ever gets legalized.
Yeah.
That's what you're saying?
Yeah. Remember, right now, all those cases sit at oath. Whatever the incompatible use is, if there is indeed incompatible use, it's been going on for at least 8 years.
The difference would be we don't know that. I guess we would actually say that we know there's an incompatible use and we're allowing the use to continue to operate.
Right, without having confirmed in any way.
And now I think that puts the board in a real, now you're saying, in essence, this person can be spray painting, and I'm just making something up. I'm running refinishing business in here and I'm spraying chemicals and everything else, and I'm not going to shut this down. I'm going to know that it's operating because they're in the legalization process.
Yeah. So I get your point, and I like the first piece, in legal operation, because I know sometimes there can be some, if you weren't legally operating, I mean, inherently incompatible use in the first place, this probably shouldn't count. But then that second piece, that it doesn't, first of all, which is suggesting that that inherently incompatible use doesn't pose an immediate threat. All inherently incompatible use doesn't pose an immediate hazard. It's problematic to me, and then that it remained okay until the building is legalized. I think that's what you're saying, and that's kind of problematic.
Yeah, and we have an overriding legal problem with this. So, under the definition of an IND, if you have the inherently incompatible use, you're defined out of an IND. And therefore, legalization is not, you have no opportunity to legalize under the law if you're not an IND. So you can't simultaneously have a property that's not an IND under state law and under our regs say it's an IND such that it can be legalized. So this is definitely ultra virus. This would have to come from the
I agree.
legislation. Yes. we can't do this by road.
That's where, I think we should put that in legal operation, or don't you think?
Yeah.
Yeah, it feels,
No, I think in legal operation makes sense.
yeah, it makes a lot of sense.
My only question about that, and obviously one way or the other, I have no vested interest in one way or the other, but does it really, if the issue is health and safety, does it matter whether or not the operation is legal or not? So you're, have a spray paint, you have an illegal
Well,
spray
they have to
painting
discontinue
booth.
it, basically.
You have
Well,
an
that
illegal
component, they-
spray painting booth that was there during the window period and during the trial, but it was still illegal and it's still there.
Well, it shouldn't have been there, right? It's legal, so they would have to get rid of it anyway. Right?
So how does it play out? I'm just trying to think through the process. So the tenant files a coverage application and says, I don't think that there are any inherently incompatible uses in the building. And the owner comes back and says, yes, there is. There's a spray paint booth.
Yeah. Or let's, not to interrupt, but let's use a simpler scenario. Something that's more,
Radioactive. It's always
no,
expensive.
something that can happen, like I can see where someone who's not paying fair will haul in a bunch of propane cylinders and say, oh, I got storage of 1 million gallons of pounds of propane cylinders here, and it's inherently incompatible with resident, it's now inherent incompatible use. So, and that's not legal, right? And that can be taken away. You would never, I would think we'd be able to order.
We would confiscate.
Yeah, and it could be ordered away from there, so it's not like that should be a disqualifier from having, from the building being covered.
But if you have an owner that during the window period is storing an excessive amount of propane, right? And
So continuing.
yeah, during the window period and continuing is storing an excessive amount of propane.
Yeah.
That still poses a danger from a health and safety standpoint to a whole lot of people,
Yeah,
not just the
I'm saying we
residents.
can deal with that if it's continuing and it's not legal.
Well, propane, in
then
some
you-
regards, this spray booth might have been more realistic thing, because propane, there's extremely stringent requirements on propane throughout the city, loft buildings or
But
otherwise.
it's more portable, no? It's more portable, it can
But
it
it
can go and come.
is something that can come and go.
Yeah.
I have a bakery, and my buddy says to me, hey, I got some stuff I need to store. And I said, you got some available space, can I store it? I don't know the propane tanks or, so now I'm getting $50 a month for storing propane tanks for my buddy. That should not be grounds to exclude residential unit coverage.
Well, I don't know that it would be, because like I said, if it was known, if in the process of what we tried to achieve prior to shifting gears to this, it was determined that that was in there, it has to go. I mean, it can't stay there. I would hope that nobody would certify under the penalty of perjury that there's not 50 propane cylinders in the unit next to me, if they actually knew there was 50.
If I do,
Some
yeah.
units in the next to me.
So what does it really add when we add in legal operation? What would we really?
So I think the import of it was that if something was illegal, if there was an inherently incompatible use that's illegal to begin with, that should not trump coverage under the loft law. I think that's the import behind it, am I correct?
Yes.
Yes. So I guess the question is, how do you, and I think it's a really good thought, and I actually agree with that. I'm not sure that the way that this is worded does that. and we would need to think about the drafting issue. But still, if the business is not shut down, it's still there. So how could you should we grant coverage in that situation?
Well, if you use the.
I'm sorry, how do you reward that illegal activity with not granting the road?
I'm not saying that the board should. I'm trying to do it from a very on-the-ground perspective, right? How does it play out in real life when we have a pending coverage application and there's this illegal, incompatible use? That business has to be shut down somehow, right? I don't think anybody agrees that.
Or the hazard has to be.
Right.
But if you used your scenario with the bakery and the guy's pressed for money, so he decides he's going to let somebody store some propane, the bakery's not the illegal problem, the storage of the propane is the illegal problem. So you remove the propane, Mr. Delaney Bakery or whoever, and you go about your bakery business. That's what you're known to be doing there.
Right.
So if the owner, if there's a known incompatible use going on at the time of the filing, as long as the circumstances don't change down the road somewhere to now, not only is there a chair refinishing company that's operating here within the law, but it's an incompatible use. But now there's believed to be propane storage. Well, propane has to go because that wasn't part of the original.
It's not legal.
So basically, during the trial, somebody, let's assume the tenant in this case, makes an allegation that there is an inherently incompatible use, but it's an illegal inherently incompatible use. So during the trial, that information has to be conveyed to the authorities for enforcement, which may or may not happen. Is my question? Is that right? Or enforcement, we assume that enforcement will happen and it'll all go away and it'll be okay? I'm just trying to wrap my head around how it would work. I agree with the principle, but I'm trying to figure out how it's going to work. So.
Work on work. Just to throw a little monkey wrench into it, you can't imagine the amount of material that artists buy and use in their studios that are toxic.
But they're allowed to have certain permittable limits.
Well, I'm not even sure what that is, but fixative is very toxic. Markers are very toxic. Turpentine is very toxic. Some paints are very, very toxic.
Well, no,
Like that, you know.
We're talking about use groups,
I-
right?
Right,
Well,
yeah, we're talking about use groups.
As long as, that's right, as long as we're able to eliminate that with the studios, then I'm comfortable with this. But if we start going into this more and more, and there are instances where there was one artist that used markers and he went out in the country and he was making these things and it was cold and he kept his window of his car closed and he died right in his, you know. So as long as we sort of keep it to a certain extent where we don't overdo this thing and start getting into the studios itself, I'm perfectly satisfied with this. And maybe I shouldn't even say this because...
Well, if we can agree before Mr. Delaney comes back. So where are we headed?
So, I mean, if the board is in favor of adding it to the proposed rule, I think that's the first question, is are we adding it to the proposed rule changes? And if so, then I'll try and draft something, staff will try and draft something that will nail down the concept in a way that is agreeable to the board.
Okay, could you state again what the problem is that's trying to be solved? I've lost sight of that.
I can state the problem.
Yeah,
So you
yeah.
have a building that has an inherently incompatible use during the window period, but it is illegal, okay? So tenants file for coverage, and everybody agrees there is an inherently incompatible use in the building, but it is an illegal inherently incompatible use. So why should something that is operating outside the law, right, be used to deny coverage to people who are entitled to protection under the law? So that's the issue. So that's the issue.
And you at first said something like, with the safety concern being an issue,
Right.
it shouldn't matter if it's legal.
Well, that's what I'm saying from a practical standpoint.
Yeah.
If health and safety is the issue, does it really matter if it's legal or not? And then how would that play out? Well, if it is an illegal, inherently incompatible use, this is like too many eyes for me, then that should be, the outcome should be that that use goes away and that the tenants get coverage.
Not necessarily. So you could then get an incompatible use that happens to be legal. I mean, it's not the case that the two run in tandem.
No, but I think this is meant, and correct me if I'm wrong, Mr. Delaney, but I think that this is meant to deal with the ones that are illegal. If it's there legally, then it's allowed to stay. The law says that.
Okay, so this is only addressing...
This is only addressing ones that are there illegally.
Is it addressing the use or the, because what I'm concerned about is, I'm looking at this one is, if you remove that illegal practice, you still can't add illegal, say industrial use.
Yes.
Maybe into that. So
No,
we should-
no, you can't move something in after the window period, such that it would be
No, so
inherently
if it's
incompatible
like
to
a
deny.
propane tax, and the guy says, all right, I will remove the propane tax, but this is still incompatible with.
Well, then you would have had a legal incompatible use.
Okay, but just to make sure that the language reflects that it's, allows for the removal. So you're not creating like this loophole that allows for someone to say, okay, because they have the propane, you allow it, but in fact, the person could just say, well, if I just remove the propane, it's still an incompatible use. I just want to make sure the language kind of reflects that.
So here's, again, back to the legal issue about the statute. Would the rule be rewriting the statute? I mean, shouldn't this have been a legislative choice if the legislature wanted it this way? So I think you have the same ultraviolet problem.
No. Can I say something? My interpretation of in legal operation is just to make sure people are double checking with the use group and zone. Whoever's reviewing the case, so that they don't miss the fact that this entity, this tenant who's commercial shouldn't even be there in the first place, right? It's just a checking to make sure that it's legally allowed to be there. That's how I read it, right? Because I could picture somebody missing the fact, a lawyer who doesn't know architecture or zoning well might miss the fact, just like examiners miss the fact that a building's a loft law because they forget to look at the check. There's a chance of a mistake, and so I think just saying in legal operation just brings it
But
forward.
that, of course, raises a host of issues of what does it mean to be legal. So if your permit lapsed, but you're otherwise allowed to operate under the zoning, is that legal or illegal? That's a... Once you tinker, you open up a whole host of other problems.
Can I offer a case scenario, not specific, but this may help clarify this? So, if Engine 5 this afternoon went out here to a Loft building, as they do when they're routine building inspection, and they come upon some sort of hazardous use going on in the building, they're going to, as soon as they see that it's a Loft building, they realize that there's issues there within the loft law in the state of New York, okay? going to refer that before they make any decision. Now, unless, again, propane is, I kind of like the word propane. It's like we're talking, it's real high-end stuff. But wait, they're gonna call into the fire prevention office and they're gonna say, look, we're at this address, it's a loft building. There's somebody in here that's soldering together jewelry, or there's somebody in here that's doing whatever, chairs, what have you. Okay. So we're going to check and determine when did this operation go into existence, and if it's in the period that allows them to be in existence, then the only thing they would have to do is make sure that they had permits for. This kind of ties into what you're saying. We're not going to let somebody have 3 55-gallon drums of, what did you say, turpentine or something like that, but I think they're allowed to have like 2 or 3 gallons of it. Maybe. So all they have to do is bring their limits down. The business may technically not supposed to be there. Oftentimes we'll do a referral to the DOB as well to get their opinion, but the magic word is written right on the DOB printout, loft building. It's under the loft, it's under the loft staff. So I don't know if that helps clarify any of this up, kind of like a real world process for how this would go down. But thought that would clarify.
Thank you. Yeah, well, are you saying, so legal use allowed per Department of Buildings zoning? Plus the legal operation of a business?
We rely very heavily on the DOB's record keeping when it comes to certificate of occupancy and such. But on a loft building, when you pull up the DOB website, it will tell you that it's a loft building. And we as the fire department, well, in my case, not so much because I'm supposed to be like a loft expert, but we as the fire department, the guys out here on the street, are trained and educated enough to know that loft buildings, okay, there's some leniency there under the state law that allows certain things as long as they were within certain window periods. So those officers are going to call into fire prevention and get some sort of clarification. Can this be here? Can this be here? If it's easily determined that, you know what, yeah, it's been there since 2007, it's within the window period, it can be there, okay? Then they're going to say, okay, well, how much varnish are they allowed to store?
Right.
And I'm going to say, well, I'm going to check with the district office, and the district office is going to say they can have, a 5-gallon thing of varnish and still be under the permissible limits. So the captain, this takes a period of time, of course. The captain is going to say, well, they got 3 55-gallon drums of them. Oh, no, you can't have 3 55-gallons of it, drums of it. So hazmat's going to come and they're going to confiscate down below the permissible limits. Or if the district office of the fire department sees fit, which probably not going to be for 3 55-gallon drums, they'll come there and say, well, you were storing 3 55-gallon drums, you have to have a permit. And they're going to put them through the permit process. Now this is on the radar screen. So every year then inspectors are going to come back and they're going to look at that line item and they're going to say, Mr. Barowitz, you still have your 3 55-gallon drums of varnish. And he's going to say yes or no, and the inspector's going to say, could you show me please? He may say, you know what, I'm retired, I got out of the business, I got rid of the varnish. We're going to make note of that and subtract it from the system and no more permit is needed. But it doesn't affect the fact that the business can still be there under the New York State law.
Right, I understand. I mean, that's great that FDNY is enforcing and
so I'm just
looking at hazardous use. But I guess I'm thinking this rule is I'm thinking of the perspective of the lawyer sitting in oath trying to make an argument.
I don't.
And they might not realize that operation with propane isn't even allowed there, unless we call it out.
I had to concede to like Helene or something. I know you came from both, but how would something like that go down? Maybe it came up in case and there was a concern.
Because there aren't architects or engineers in the oath. It's just the lawyers and the tenant and the landlord. So I'm just wondering if they're checking.
Architects and engineers testify. all the time.
Called as
As
witnesses?
witnesses, yeah, both sides call architects and engineers on these issues.
So, okay, I'm just trying to understand in legal operation, just to, and maybe Chuck explain why you want it, but it's, to me, it's just making sure that people checked that it's legally actually allowed there.
That's how I would.
I guess my concern from Mr. Kirk's point is you're opening up Pandora's box here. What any violation could then generate you being in illegal operation. You get a violation for, I don't know, not having lights or whatever.
No. So, in legal operation just means it's allowed.
Oh, you technically no, but if you got a violation for whatever, you're
No,
technically
a
not.
violation for something, for even a violation for improper, say improper storage doesn't mean that it's not allowed. You know, so
But this is in illegal operation, operating.
should we say permitted then?
Well, I mean, it could be allowed by the CFO, allowed by the,
Yeah.
I mean, you know, the section talks about what's the zoning resolution, so, you know, I mean, if you had, let me just ask this, if you had a use group 18 operating in a zone that's use group 16,
It doesn't permit 18.
right? It doesn't permit 18, whereas 18 permits everything, right? So if you have a use group 18 operating in a zone that's 16, that's an illegal operation unless there's a variance or whatever, right? So is the import of this to say, well, that use group 18 that wasn't legal to begin with shouldn't be used to not grant coverage?
Yes.
Yes. So then we get back to Mr. Harper's point, where the rule doesn't actually talk about legal or illegal, although I think there could be a colorable argument to say that the legislature was only thinking of uses that were allowed.
Why would they be thinking?
Why would they be thinking of illegal things? I think they were concerned about the people that were legit, you know, they were concerned about the legitimate people that were there, that were allowed to be there, and the manufacturers that were there, and not making them move. I mean, I have to check the legislative history. The legislative history for these amendments is not so great, I have to say. But I think that the concern was to protect businesses that were legally operating. So I find it hard to believe that the state would have approved of not granting coverage because somebody's illegally operating. I don't think that the legislators were thinking that. So I think there is a
No, but there's the
colorable argument.
safety problem. The
Yeah,
actual unsafety.
but that could be remedied by getting rid of
It could
the.
be remedied, you know. What I'm saying is if something is illegal, then the remedy to that is to make it legal. Or, you know, get rid of it completely altogether. It's not legal.
But you're not going to hold the tenant responsible and jeopardize the tenants. Right? That's
Well,
where
it does,
you're
though.
going with this.
But the way that it's drafted
So
now, it
in
does.
other words, because something had been going on in the building, an incompatible use had been going on in the building, even though it started in the window period, the tenant wouldn't be able to get
Coverage.
coverage.
So if you had a use group, if the building is in zone that allows use group 16 and you had a use group 18 in that building during the window period and continuing, that tenant can't be covered the way that it reads now.
But he or she or they are living there anyway.
They're living there anyway.
So coverage is kind of a moot point. You're living there.
Oh, but then the landlord can evict them if they don't get coverage.
So,
Or can evict them.
this
Like we
Or
had-
should
we had a
I'm
case-
kind of
let
in
me
your
take it.
direction on this, saying,
Yeah.
why should the tenant be?
No, the landlord can evict them, or the landlord can simply allow them to live there without being a covered unit.
Right.
So we perpetuate whatever the health and safety issue is.
Sorry, the landlord would allow us to live there.
Sure, yeah, no, that's the problem with all these exclusionary provisions. So that-
But we also don't have the ability to do away with the unimpaired use as long as it's within the accept of the use group, correct?
If it was a legal use that was there, like if it was a 16 and a 16,
Right.
and there were no other legal impediments.
Right.
then no.
So we
wouldn't-
can't
wouldn't
do anything
eliminate
about that either.
Well, I normally don't go anywhere without my Article 7C, but I left it under my pillow.
Well, I have it.
The piece of language that gives us leeway to interpret.
The Loft Board may by rule exempt categories of units or buildings from such use, incompatibility determinations. It's 281.5.
Yeah, that's the language, but it's also hopelessly vague. So, Elaine, your suggestion that we look at some of the background history of the legislation, that's probably on fault here to see whether or not this change would be in furtherance of the intent or would be changing.
I mean, I'm willing to do that, but my recollection is that the legislative history for this particular piece is not
It's
very
bad.
full.
It's very thin.
So we want to revisit it next month? I can do some research and we can revisit it, or but if the board is against making any change, against adding this proposal, then I don't mind doing work, but I'd really rather not if we're not actually going to consider going forward with the proposal. So I guess.
Well, I like the component about in legal operation, but to Robert's point, or someone was saying, or maybe you were saying, it could say permitted as of right under the zoning.
It has it right under zoning, or?
Yeah, I think I'd be much more comfortable with that. I still do think that the legal operation can be translated. If someone forgot to get some sort of certification from NY, they would find some way of being able to test it. So it would make it much more powerful.
How about legally permitted?
And that goes back to like someone forgot to file some stupid paperwork.
They didn't say that.
They didn't pay for some
There is no
district operation. Somebody forgot a district operation inspection, you know, and that immediately was stuff, you know, they forgot to do it by a week and they find out.
So legal permitted in the use group? First off,
I don't know, because you could have a business that was in operation that had a variance. So, you know.
well, if you did a variance, it's
It's
variance.
legal. Yeah.
It's creating, again, new trails of the problem. And then you still haven't necessarily solved the safety issue.
Excuse me.
What's our schedule like for today? Well,
We're going to break. We're going to finish this thing today.
Right before.
some of us have to get back to the office, so what's the...
12:30?
all right, I can hold out.
Maybe you bring even lunch.
I lunch, you
I
know.
know.
Notice he always brings some sort of sustainment to all of you.
Okay, Mr. Bobick has something to say.
Mr. Bobbitt will approach the bench, so, Mr. Bobbitt, you got to come on.
I gave a bad example, and he's right.
So,
Make sure the mic's on.
It is.
so I read the statute as if you fall within 15 to 18, you cannot be an IMD. So regardless if you have a use that falls within 15 to 18 and it's legal for that zone, it doesn't matter. You still cannot be an IMD. So I'm not sure what legal operation will do if it's a 15 to 18 use group.
No, I think what he's, yeah, so what you're saying is that that use is brought in to, that operation is brought in to kind of I could kind of circumvent that, or to override that what would have been normally illegal. So you would not, so
But it wouldn't be an ID. If you're in 15 to 18, who cares if it's legal or not? If it's 15 to 18 use group in a building that's on the effective day of the law, continuing on the date the application is filed, it's an incompatible use, the building is not an IND. So if a use group is a legal use group, and you're an IND, it doesn't matter. But if you're a non-IND, and it's a 16 and a 16, go for it, have a party. But if you're a 15 to 18, it's my reading of it is you can't be an IND. So it doesn't matter if the use is legal or not.
Thank you.
Stay there, stay there, stay there.
However, we went through all the uses in groups 15 to 18 and excluded them. So I'm not sure I see your blanket interpretation.
But the statute, does the statute exclude?
Or did.
I'm asking you, if the statute as written in 281.5, does that exclude uses in 15 to 18? Because my reading of it is it doesn't. So my reading of the statute is if you're in a use group 15 to 18, and a tenant or an owner, it's raised and it's proven, then the building's not an IND.
Even if the board excluded it, I mean, you have a historical, which says if the board excluded it, if it was one of those that the board exempted, a category that the board exempted.
But that plays into what you kind of been hitting at here, which we can't just make a determination and assume that the statute, nullify the statute. If the statute still exists.
It says 15 to 18 in the statute.
Right, so
Yeah.
we said, well, we're going to exclude these, but the statute still says they exist. And the statute trumps.
No, but the statute allows the board to exempt. So let's, I don't know.
Where's the exempt list? Is there?
Yeah, it's in the appendix.
It's vague in the statute.
It's in the appendix. I don't actually have that with me, but I can get it to you. But let's say cardboard manufacturing. Why I think that. Let's say cardboard manufacturing is in use group 15 to 18, and the board by rule exempted cardboard manufacturing for some reason. Oh, I'm so confused. I'm sorry, I can't.
I would
remember
say
the question.
if instead of legal operations, and if the board has exempted a few uses, then you should cite to the exemption list. If it's a use within 15 to 18 that has been exempted by the board,
Well,
there's an exception.
but then they could be covered anyway.
Yes.
So it would be a use.
Instead of legal operation.
You don't need to take the exemptions because this rule is the exemption, no? These are the exemptions.
Yes, it is.
Yeah, so.
Plus
so
the appendix.
Right. So there's no need for the change.
So let's go back to the author and see, Mr. Lennon, are you still, are you convinced otherwise?
No.
Okay, so you have the last word and then we'll have to move on and then we'll come
Well,
back.
as Elaine earlier said on the question of the legal operation suggestion, that you agreed with it, that it was an issue of drafting. And I understand the question of elapsed permit versus some wildly illegal use. So I would ask that the staff take a look at this and see if there's a way to fine tune it and bring it back.
Okay, we'll do that.
But we still have the problem raised by Michael.
Right, so Michael's on staff.
We'll consider,
We'll
we'll
consider
consider
that.
that part of the discussion.
Right.
Okay.
Yeah.
Thanks, Michael. You really helped us with this tremendously.
at the last meeting that we take a look at the submission from Mr. Brody and Laura Goldstein concerning the narrative statement process. So we're going to go back to that and hopefully we can wrap that up. And then next meeting we'll get to Section 8, which is the protected occupancy rules. I'm sure we'll engender a lot of discussion. So Mr. Brody had this proposal. It's a letter dated May 17th, 2018. So maybe we should start, Mr. Brody.
Yeah, sure. So one of the problems with the narrative statement process, and we've actually spoke about this in other meetings, is that it's really loose and that it's subject to you know, if a tenant really wants to put the brakes on the process, the tenant can. And the tenant has the incentive to go slow because if the owner is out of compliance with certain timeframes, the owner is not able to get rent from the tenant if the tenant stops paying. Now, that's not to say that every tenant does this, but there are tenants, and it could be one tenant in a large building that stops the process even when others wanted to move forward more quickly. So what this does is it puts milestones within the narrative process so that the tenant has, in the proposal, the tenant would have to make an objection to plans within a certain amount of time, and if he failed to do that, the ability to object would be waived. Now, in the past, when we talked about this concept, I got a lot of blowback from members of the board saying that there's a fairness problem because, you know, tenants aren't always fully informed of what they're looking at. And then there's the potential to, you know, if under the current procedure there's abuse of the process by the tenant possible under a provision, there's potential for the owner to be the one who abuses the process. But I think as drafted, by setting milestones and allowing for extensions for good cause, we would definitely overcome problems on the tenant side. And of course, a tenant would never be bound by any subsequent change that happened. And by the same token, an owner would also be bound by certain promises that the owner made in the course of the process. So what the proposal does is that it tightens up and it enables, I think, the owner to have final plans at the end of the process instead of receiving the tenant's objections at the end of the process. So this is a way of tightening and trying to move things faster. It's similar to the ideas that I had talked about previously, but here it is in writing with safeguards for extensions on the tenant's side when needed. So if it's something people are interested in, I know I am, I would ask the staff to work on language for this concept. And I should ask, is there any interest on the part of the staff in this kind of procedure?
So I have some problem. Sorry, I have some issues with this exact proposal. You know, I think streamlining things is always a good thing from my perspective, but I'm not sure that this proposal actually streamlines anything, and I think it actually in some ways gives tenants more time than they had in the past. But I have a lot of questions about it. I don't know that I should be leading the discussion. Okay, so the first part of the proposal says that the owner's plans, narrative statement, objection sheets would need to be accessible online, and tenants' architects could still request a hard copy. So my first question is always going to be a practical one. Where online? Is that something that the Loft board is maintaining? Is that something that the owners are going to be maintaining for the tenants to look into? How does that work? Because if it involves somebody sending stuff to the city, that could be a whole lot of problem IT-wise. So just from a practical standpoint, that could be difficult, but not over, but it could be overcome somehow.
Can you just answer that? Do you have an idea?
No.
Okay.
So
that was my first concern. The second concern, which is overall, is that it seems to be removing the face-to-face interaction, which I think is bad. I think a lot of things get accomplished when people are sitting at a table and looking at each other. So this contemplates having, the owner file something and then the tenants have 45 days to write back. But it also says that the tenant has 45 days to file an application or an alternate plan. But if the tenant sends comments within 45 days, then the owner has the right to respond to that. So I don't follow it. It says the tenants would be required to state their disagreements with the plans in writing. But then later, it says that tenants would have 45 days from receipt of the original narrative or amended narrative to file an alternate plan. So they can either state disagreements or file an alternate plan. I'm not sure how that's supposed to work. The process isn't flowing for me in my head. Also, it says, well, to the extent that the owner on page 2, they're not actually numbered, but on the second page, the proposal says, to the extent the owner accepts the tenant's proposed changes, objections, those issues would be foreclosed from further comments, subject to DOB rejecting said proposed changes. Well, that's all well and good. Okay, that kind of makes sense. Well, what if the owner doesn't accept the tenant's proposed changes? What happens then? Where do you go from there? And then what happens if DOB does object?
No, but I think you're still within the regular process. I mean,
For the objection sheet, would you be waiting for the owner to have his objection sheet set, which could take 6 months on its own? Or are you saying it's a fluid process that every time there's an objection, you're posting? Because, you want to know what the objections are, and the tenants want to know what the objections are. So you may have a big building, it could take 5 months to get every single objection raised. But during that time, the owner is already clearing these objections. So in this proposal, you're saying the owner won't have any contact with the tenants for the first 6 months.
Just throwing that out.
yeah.
Moving on to the paragraph about the CCD1s. So the paragraph about the CCD1s presupposes that the tenants have an architect. So I don't know that we could necessarily require tenants to have an architect, but clearly a tenant, unless the tenant is an architect, which does happen, a tenant can't file a CCD1 unless they are an architect or somebody who's allowed to do that. Or an engineer. And then it says that in the event the CC1 is not successful, the issue which the CCD1 was filed would then be foreclosed. But there are appeals from CCD1s, so why would we want to do that? Why would we want to just stop it at the first process if there's a possibility of succeeding on appeal from a CCD1? And that has happened in the past, where there have been appeals from CCD1s and borough commissioners have worked with the parties and come up with something. So I am not sure why you would want to just foreclose it after a CCD1. On the next page, that's the issue that I raised about which 45 days are we talking about. It seems the proposal seems...
Before you go on,
yeah.
I'm sorry. So why do they want to limit themselves to just the CCD1?
Why would who want to limit themselves?
The owners are saying they go further than that. For our process, just wondering.
Because from a legalization standpoint, you might be able to legalize with less, without unreasonable interference or diminution of services if you go past the CCD1 requirement, right? So you get in front of something, because a lot of it involves waiver, and you have to be at a certain level in the department, in the DOB, correct me if I'm wrong, but don't you have to be at a certain level within the DOB to actually get those waivers? You know, a plan examiner may say no, and then the CCD1 doesn't go to the borough commissioner, it goes to somebody else.
Isn't the same CCD, another appeal of CCD1 that goes to using the same CCD1? It's like the same. It's just the same CCD1.
Chief planning examiner,
that goes up to so that an appeal of the CCD1 that goes a little further than just the technical that goes native to the first deputy commissioner or something. But I'm just saying, so after, and I'm not speaking on behalf of the department at all, but I'm wondering if there is not a process outside of the department for appeals of CCD1, such as VSA. No, I am not wanting, I'm just saying, it seems to me that this owner's architect is proposing that the appeals stop at CCD1, correct?
This proposal says that, well, first of all, it puts the burden on the tenants to file a CCD1.
Oh, I see.
And if the CCD1 isn't granted, then that's it. You don't go anywhere else. And I see no reason to stop at that level, because the person that's deciding the CCD1 may not be at a level high enough to feel comfortable with giving a waiver, because a lot of this involves waivers that the commissioner could do. I'm thinking of like handicap stuff is the example that's coming to my mind, where, you know, a plan examiner or a deputy plan examiner or chief plan examiner may not feel comfortable doing that, but the commissioner has the authority to issue a waiver. So
I thought this was one of those.
Well, this proposal puts the burden on the tenants who want a CCD1 to file. It shifts the burden to the tenants to file that CCD.
And stop there.
And then stop there. That's what it says. And I don't...
Does it allow for the provision to then amend? Because you can submit as many CCDs as you want. There's a rule change. There's a rule change.
2 of them?
There's a rule change.
Right, you just get 2, right?
I think so, and then the cost is enormous.
Yeah.
Exuberant.
1,500 and then 2,500.
Yeah, it's a lot of money. Which could be one of the reasons that the owners want to shift this to the tenants. So anyway, you know, and if it's something that would be required for legalization, then I don't see why the tenants should have the burden of filing the CCD1. So anyway, that's my comment on that. On the next page, on the third paragraph down, any application alleging undue interference would receive expedited scheduling by the Loft board. You know, I think there's certainly nothing wrong with that. We would have to talk to Oath. So, you know, I think that we could change our rules to require it, but we need Oath to be on board to actually do that. So I'm just pointing out that that's something that we would have to do. I'm not saying that we're not willing to do it. I'm just saying we have to. Okay. Then the next one, I had a lot of questions. Any agreement whereby the owner will provide more than the minimum work required to legalize, determines what's the minimum work required to legalize? That could be an issue of fact. A premises or public portion of the building, why should tenants sign off if the owner decides to do more than is required in public spaces? Maybe it's because I just don't understand what that means. So I would need clarification on that to really understand what they're talking about. In terms of partial certifications, I mean, I'm leery of doing that. We do it now for health and safety concerns. We'll do it for sidewalk sheds. We'll do it for heat. I think the idea behind the whole process is to have everybody see to see the big picture, what it's going to look like in the big picture. And if you start issuing a lot of partial certifications, you can lose sight of that, and it could wind up bad for everybody, and certainly bad for tenants. And the permit, when they pull the permit on the Alt-1, they're pulling the permit for the entire job. I mean, we had this recently where we have a building where everybody was ready to go except for like 2 units. And so, you know, we lifted the hold and let them pull the permit, but the owner was told that they can't work in those 2 units, but technically, legally, they're allowed to work in those 2 units. But our certification said that they can't work in those 2 units, but legally, the permit itself allows them to do all the work that's in the plans, which would include those 2 units where there hasn't been a determination because it's still an oath. So, you know, I understand the idea of letting the work commence, but I think there has to be an agreement on the big picture before that happens. So maybe there's some middle ground there that could be reached. But we would have to think about what those parameters would be. So that's what I have to say.
You know, I'm thinking I should ask the author to think about your points.
Okay.
See if there's anything that can be crafted to really better move the process along. Because this non-payment of rent for owners is their number one issue, and this is part of the problem. The length of time that the process takes, and the ability. Tenants who don't want legalization, and that's not everyone, obviously, but there are some who would prefer not to pay rent and to have the property legalized. I mean, that's just a fact. Having said that, so one solution to this problem is to have this process more streamlined, but the other lies in a change to one of our rules that seems, I believe it forecloses an extension of the code compliance deadlines to just one time.
Yeah, that's how it reads.
Okay. Now that, I believe, that wasn't always the case. There was once a time when you could get more than one extension. And when I say extension, I don't mean because the owner's lazy, I mean because they have costs.
Yeah, well, I mean, so pre-2006, owners could actually apply ex parte for an unlimited number of extensions, and my understanding is that there were a lot of abuses, so the board at that time tightened everything up and put in the 1 extension per deadline rule. So that's the way that it reads now. I've taken that as the executive director who makes those determinations. I've taken that very literally, and they get one. So usually we give them 1 for all of the ones that they ask for. We don't make them come back each time.
So I guess the problem is life happens, and you sometimes need more than 1. And I think I would like to propose some sort of change so that an owner who's working in good faith could get more than 1 extension of the deadline. Because it's that once you hit that deadline, you can't collect rent, and then you can't do the work because you don't have the money to do it. So I think think what I would like to do is propose an actual proposal. You know, it'll be short, but real language similar to what we seen from Chuck in that he took an existing rule, he made some modifications, and we talked about it. I think I would like to do that and send it to you, and then you can send it around. And then at some point, I'm not saying that we need to do it next time, but at some point we should think about that proposal.
Can I ask a question? Can you quantify, I know that the landlord lobbyist is talking about people not paying rent, but I think that, to me, that is playing up the idea of squatters, which isn't true. And most people pay rent, so can you quantify that statement?
I'll ask. I'll certainly ask if we can quantify.
Because the more you repeat it, the more people start to believe it, but I don't think that's the case.
Well, I'm not talking about squatters. I'm talking about the state of the law, which is that an owner, it's a fact, it's a legal fact, that an owner cannot enforce rent collection if he's out of compliance with the deadlines. That's a fact. So now,
is there escrow for rent?
Well, I don't know. I believe it's no, right? Yeah, no. And from my anecdotal interactions with owners, it's a big problem. But I will certainly ask to see if there's a sum total type of number for you. I'll certainly ask.
Yeah, I'm just curious because I think most pay rent, and I realize it's there, but I don't think people use that.
Why do you think that? Because I'm being told just the opposite.
Well, it'd be good to have clarification if you're trying to direct the narrative process, which I think is the most unique and amazing part of Loft Law. If you're trying to cut it out with Brody's letter, you're taking a lot of power there that I want it quantified. I don't understand why this is a concept that would clarify it. To me, this is not a concept. It doesn't cover, it's nowhere near as good as what's written in the rules already.
We had moved off the proposal, and I was talking about getting more than one extension to avoid the rent problem. So that's another way of addressing the problem if the route that's offered by Brody is not acceptable to you.
So keep the narrative statement process as is with the proposed changes in the proposed rule, but allow for additional extensions for owners that meet the statutory standards, which are that it's circumstances beyond their control and they're making good faith efforts.
Well, yes, on the extension issue. On the issue of the narrative process, I still want to go back to him because now that he has your thoughts, I definitely wanted to address it to see if it even can be addressed. But I can't believe that the existing process can't be made better somehow. That I can't believe.
What about if it's recorded? The narrative process seems to me it would improve if it was recorded or if there were notes. I've heard that both sides.
We've heard that, and staff thinks otherwise. But isn't some sort of written, isn't some sort of agreement at the end of a session more important than how you got there? So
I can't see, as someone who's worked with clients for years and years, there's so much detail in plans. So to think that it would work via 45-day, no one meets face-to-face, is actually taking away the most unique component of Loft Law and adding to the confusion.
Okay, as I said, if this isn't going to work, there are other things we can do, but I also want to ask him for other thoughts about, from the owner's side, as to what can be done to make the process quicker, because I can't believe that it's as good as it can be, as is. I can't believe that because there are just too many complaints about it.
You want to make the process quicker, but then again, before 20, 2 extensions, 3, multiple? I mean, what exactly are you hoping to gain by allowing the landlords to have multiple extensions?
Because they can then lawfully collect the rent. And you need the rental income to make the work happen. I mean, the last 2 months we've had buildings leaving the jurisdiction that have been in here for 35 and 40 years. Now, I know it's not necessarily the tenant's fault. I mean, there's fault on both sides for that. But the inability to collect rent because you're only entitled to 1 extension is a huge problem. And things happen outside of the owner's control where they need the extra time. And you're not helping the process by enabling tenants not to pay rent. I mean, the process relies on that income.
Just for edification, we're talking about 29 RCNY 201B3. That's the section of law that has the applications for extension of code compliance. Deadlines will be limited to 1 extension per deadline in the amended code compliance.
All right, so I'm going to circulate, it'll be short, just some changes to that I think would be helpful.
Okay, Mr. Carver, you have the last word. So we're going to break here, and unless someone else today. Okay. So we're going to take a break here. I appreciate the debate. Say, hang in there.
With regard to the meeting schedule for June 21st,
Yes.
Is it anticipated that we'll be doing cases as well as coming back to the rules?
Yes.
And do you have a sense of where we're going to pick up with the rules?
Well, I guess we'll go back to the inherently incompatible use that's being drafted. I don't know whether or not we're going to get more feedback from Mr. Brody, but if we don't, then I would like to move to protected occupancy.
Okay.
Unless you want to skip over protected occupancy and do the fines and then come back to it. But
On the issue of extensions, that's something we should wait till the very end of.
Oh, we could do, yeah.
It's up to you.
Yeah,
It's up to you.
we could talk about the proposed extension language too, if you want to do that. You just want to know, so
Yeah.
you're prepared, yeah. Okay.
Yeah, I was curious about that. So we will, the Friday before the next hearing, we'll have an agenda for what's
Yes,
on the 21st.
hopefully sooner, but certainly by the Friday.
Also, just to clarify, we're not going to have any meetings in August, right? No rules, no cases, or is that?
We're trying to avoid it.
Okay.
Trying to
I mean,
avoid it. There's no guarantee yet.
Just, it doesn't really matter for me, but for some.
Yeah.
Because I know historically we don't meet in August for any reason, but I thought maybe since we were dealing with the rules that perhaps we could do it.
Things haven't been too historical recently.
We'll see how far we get in the other June meeting in July.
We're trying to avoid it. This will conclude our June 7th, 2018 Loft Board meeting. So our next public meeting will be held here at 22 Reed Street, first floor, on June 21st at 2 p.m. Board members, please remember to turn in your attendance